to me, the biggest legal news, unfortunately, in this setting was the Carter Page case that I hope the Supreme Court takes up. The D.C. Circuit's not a likely circuit. And by the way, this was a district court judge appointed by Trump. It was very predictable because
sorry, I didn't mean to cut. I didn't need to. I'll just read this part of it. We're going to get to the fact that the lawsuit was dismissed. Carter Page has no remedy. Just to bridge this from Trump to Carter Page, this is in the judgment. It's towards the end. As alleged, the FBI's conduct in preparing the FISA warrant applications to electronically surveil Page was deeply, quote, troubling. Indeed, the government has conceded it lacked probable cause for 2 of the warrants. Okay, fine. And the FISC has found that the government violated its duty of candor in all 4 applications. This is the same Department of Justice, FBI, that we are now expected to not question. If you do question them, you're a MAGA Republican, enemy of the state, enemy of democracy. So that's the segue, because anybody who's scrutinizing and questioning what the Justice Department and FBI are doing with Trump now, that was what was true of them 3 years ago, 4 years ago. I'm sure they've changed. But Robert, Carter Page sued, I forget under what provisions. He sued for damages
he sued under a bunch. So he sued under the Foreign Intelligence Surveillance Act. He sued under the Patriot Act. He sued under the Privacy Act. He sued under the Fourth Amendment to the United States Constitution, known as a Bivens claim. He sued under other related claims that come up within the within the Federal Tort Claims Act. So he brought every conceivable claim. And a judge appointed by Trump, who was one of his bad appointees, and you could know that because spent a lifetime came from the elite academies, then worked as a U.S. attorney for a long time, then was a big Bushite and was one of Bush's top counsel. Why in the world Trump appoints someone like that to the bench, who I guarantee voted against him every time? Extraordinary. And the judge finds excuse after excuse after excuse to prevent Carter Page from getting an iota of even discovery to support his allegations or accusations in the case, to even amend the complaint to add additional alleged allegations and facts in the case. And the most ludicrous part of her ruling is the Fourth Amendment ruling, and the most dangerous from a precedent perspective. Because the short answer is this: you have massive illegal spying on Page. She acknowledges that's not even in dispute. You have extraordinary efforts of deception on courts to obtain those illicit warrants. You have illicit use of those warrants and public disclosure to third parties to defame and libel Carter Page concerning them. If this case, you have Privacy Act violations of not correcting records or not giving records in a timely manner. If you have classic version of abusive process, the use of a process for political aims other than what it's intended for, in a weaponized manner and in an illicit means. And yet this judge says Carter Page can't sue at all, can't sue anyone in the government, can't sue the government itself, can't sue any agencies of the government, can't sue any people on any claim, on any basis, at any time, to even get discovery or the right to amend a complaint. And she makes it sound like she's, bothered by what took place. If the judge was being honest and was actually bothered by what took place, she would have granted amendment with leave, with direction about how to get there. She would have allowed discovery to take place in support of those amendments. She did neither. In fact, she said the most disingenuous statement in the whole order is her statement that the reason why there's no cause of action under the Fourth Amendment, because she makes a ridiculous ruling, in my view, that the Fourth Amendment is the fight. Everything, if it concerns FISA, the Foreign Intelligence Surveillance Act, the Fourth Amendment magically doesn't apply anymore. Because, again, the U.S. Supreme Court has said Bivens is still alive in the Fourth Amendment. Now, again, it's because of conservatives on the Supreme Court that we don't have more constitutional remedies. It's conservatives on the court that are leading the fight to gut civil rights in America in a range of cases. And there's a lot of people still in denial about that. But we discussed it when it came up earlier this year, where they gutted Bivens cases for anything other than the Fourth Amendment, basically. So federal government can violate all your rights and you can't sue. Ha ha ha. That's the great constitutionalist on the court. save it. They also foolishly believe that standing doctrines and other doctrines are really good to limit courts' judicial activism. No, all it does is keep conservatives from being able to sue, because liberals will screw them and conservatives will screw them. Congratulations, you dimwits. But what took place here is a classic Fourth Amendment violation. That's what this is. The search and seizure of information about an individual without probable cause. It's a Fourth Amendment violation of reasonable expectation of privacy, etc.
The judge acknowledges that they lacked probable cause for at least two, and I forget what the problem was with all four. So she admitted. It's admitted. The question is now, Robert, motivated reasoning being what it is, how's she going to get out of it?
Yeah, and what she does is she says FISA is an exception, which makes no sense at all. It's like she said, so what she's doing is she's playing off of this political prejudice by conservative judges to try to to expand immunity, expand standing, say, hey, we got to let Congress set these rules. And some of that is well-intended. It's just going to be misapplied in his poor political handling of these cases, in my view. Aside from being, I think, substantively wrong. All these cases should be decided by juries. Immunity shouldn't exist. Whether you did it in the name of the government can be a defense, and that's it. And you have to have complied with the Constitution for it. That was the understanding at the time of our founders, and for a long time thereafter. The standing doctrine was made up in the 1920s by lazy judges to get rid of political cases so they could play Pontius Pilate. That's what it was, what it is, what it'll always be. I'll never respect it until the day I die. And afterwards, it even less when it goes. So what she says is that's her whole claim. And then part of her excuse for this is to say, especially, there's no need to recognize a Bivens right to sue in the Fourth Amendment context for FISA when there's all these other remedies under the FISA laws and under the Patriot Act and under the Privacy Act and under the Federal Tort Claims Act, while turning around and gutting every single one of those claims as to Carter Page, showing how there is no such remedy. If Carter Page doesn't have a remedy, nobody's got a remedy. So to pretend there's a remedy is a lie by that hack of a judge, that Federalist Society judge, another failure of the so-called institutional conservatives who've delivered another abomination on the bench because she can't follow basic constitutional law. What that was a fraud on the people, claiming there was real remedy when she was gutting it for the only person who could have such a remedy.
Robert, I'll just ask the question. There was a portion of the claim was time barred because it had to have been filed within
Only
1 year and not 3 years. So that has nothing to do with the Fourth Amendment violation. What's the statute of limitations for a Fourth Amendment violation?
Oh, he was well within that. The different there was like some statute limitations were 1 year, some were 3, some were 4. So it depended on the particular provision. Some were 2.
So some of the claim was dismissed time barred. I forget which one it was.
And some was exhaustion of remedies claims. My view is it seemed to be convenient. In other words, she would find a basis somewhere to dismiss everything. It was like if she could, and while pretending to be deeply concerned. Bottom line is she doesn't want the deep state to be sued. I mean, that's the reality. Carter Page's case was about deep state corrupt actors being able to be sued on an individual and institutional level. And they don't want it to happen. Now the deep state knows all they have to do is label their action as part of national security and foreign security, foreign surveillance intelligence, and they have no liability anywhere outside of very rare search. She said the only way you can sue, she said you weren't acquiring or collecting information unless you're the one putting the tap on the phone, which doesn't even exist anymore. I mean, that's very rare. People don't do physical taps on phone anymore. That's not necessary. It's done 100 other ways. So there's nobody that's physically, directly, personally doing that. So under her interpretation, FISA also has no remedy anymore. Foreign Service Intelligence Act has no remedy anymore. So it's gone, it's finished, it's done. Under her interpretation. And she pretends she's not gutting it when she really is.
Because people have to appreciate, like everybody does, I think, watching us now, but in Carter Page, this was the case in which the FBI lawyer pleaded guilty to falsifying evidence. The judge herself, I didn't know it was a her when I was reading the decision, concluded that the FBI, lacked candor in all of the applications. I forget what the terminology was. I showed the section.
Well, these are things she couldn't dispute because they've been found by other courts. They've been found by the government itself. They've been admitted and confessed to.
So she acknowledges all of this. And then nonetheless, committed crimes in unlawfully spying on Carter Page. All of his claims dismissed, and a dismissal with prejudice.
Well,
So
with prejudice, no right to amend, no right to discovery, none of it. So to the question in the locals live chat that we got going on, there's not much remedy involving the courts, unfortunately, other than impeachment. The courts don't discipline themselves, and so on and so forth. So the only remedy for Carter Page is to go now to the D.C. Circuit Court of Appeals, which is an overwhelmingly liberal, deep state-oriented court. Like here, even when you don't get liberal Democrats, you get deep state protectors, as people have witnessed in the January 6 cases. So his only hope is the U.S. Supreme Court clarifies its issues concerning Bivens and its issues concerning these statutes in particular, because these are matters of critical statutory interpretation. But I wouldn't bank on it, sadly. This U.S. Supreme Court has not been good in this area. It has been gutting civil rights and civil remedies, not expanding them or extending them. It's been good in a range of areas on the First Amendment, the Second Amendment, interpretation of the Fourth Amendment, but not in the areas of suing the government, not in the areas of getting remedy from the government. There, it's been mostly bad. My liberal friends in the civil rights community are quite rightfully unhappy with this particular court's direction because it's found lots of excuses as can't sue for this reason, can't sue for that reason, can't sue for another reason, can't sue for over here. It's either immunity or standing, congressional interpretation. The only one they said you could, they've said you could sue private employers over a range of things, like in the trans context, et cetera, but not the government, not deep state operatives. And national security is the magic mojo that everybody gets to hide behind. And all those people that excused and defended the attacks on Julian Assange and Edward Snowden should now see why Assange and Snowden were right. The most corrupt actions and the most corrupt actors will disguise what they're doing as national security. We should be the ones to determine whether they really did it in national security's interest, not them behind hiding their lies behind the protection and the pretense of patriotism.
I'm just pulling up the decision as you're talking, Robert, and remembering now all of the things. The issue that Carter Page ran a very successful business and then was outed as an asset to the CIA, which is very bad for business under normal circumstances.
Well, both. First he was a rising person within the coming Trump administration, within the Trump campaign, which had a range of benefits to him professionally and personally and politically. And so first they remove him from that. They subject him to massive inquisitive interrogation investigation, but they don't just leave it there. They next leak to the press that he's under investigation. So they destroy his reputation and career. And the way they got their information is pretending that he was a Ruski spy when actually he was a patriotic American trying to do good business around the globe and would repeatedly provide information to the U.S. government if he came across anything questionable or problematic, or if they requested he do so. But of course, that information ends up becoming public as well. So the net consequence is he's wiped out. He's removed from the ability to do what he used to do solely by the lies, deceptions, and misconduct of the government. And according to this federal judge, there's no remedy for that. But don't worry, there's a bunch of statutes that do provide a remedy for it, just not in reality.
Well, I'm just going to read this because it's like you go to a party. My dad once went to a party once upon a time. It was like a magician, but it was just a guy speaking English, but in convoluted ways that the game was to see who would respond to this individual as though they were making coherent sentences when the whole gag was that they weren't. And so you'd see everyone's polite, had a martini, like, oh yeah, you're making total sense. But the whole gag was that the person was speaking doublespeak the entire time. Listen to this doublespeak of a judgment. Similarly, Page alleges that the individual defendants intentionally provided false information and omitted material facts in all 4 applications. To the extent these allegations are true, there is little question that many individual defendants, as well as the agency as a whole, engaged in wrongdoing. Even so, Page has brought no actionable claim against any individual defendant or against the United States.
And that's because she radically said there's no Fourth Amendment right to sue anymore just because it's in the FISA context, and then radically restricted the meaning of the FISA laws to say that you're not conducting, performing, collecting, acquiring personal information unless you're like the person doing the tap on the phone and listening to the call.
It's amazing. In part, it's because he faces 3 statutory roadblocks. First of all, Congress has not created a private right of action against those who prepare false or misleading FISA applications. Well, isn't that convenient? That's quite.
Well, and the problem is the next statement. It actually has created a law that has civil liability for those who conduct or perform electronic surveillance. She's just pretending that you're not conducting or performing electronic surveillance when you're the one creating and using the electronic surveillance.
It's judicial doublespeak. Second,
it's all designed to be a deep state cover-up without looking like the fraud that she is.
Oh, my goodness. All right. Well, good luck in appeal, Carter, and enjoy the cost that comes along with that. And we'll see where it goes. So Carter Page is SOL, as we say.
By the way,
out of luck.
They burned a range of, they burned Carter Page. They burned it. Like, there's always talk about worry about CIA informants and whatnot. And they're somehow trying to tie that to Trump, which is nonsense. This is it's the same game. The Julian Assange thing, there's still idiots out there that believe things about Julian. It's like I occasionally run into conservatives who believe nutty things about Nelson Mandela still. It's like they don't realize one of the world's greatest human rights activists and leaders in the last century was mischaracterized and misportrayed by the deep state in the West, like everybody who protested the deep state, as a commie terrorist. If you disagreed with them, you were a commie terrorist. Didn't matter who you were. Didn't matter whether you were Priest Romero. It didn't matter who you were. Nelson Mandela, Martin Luther King, all of them. The reality, as I'll detail more in a bourbon tomorrow at vivabarneslaw.locals.com, is that he was a great human rights, civil rights activist. If you listen to his own words at the time, that's clear. There's people who still believe that. There's still people who believe that Julian Assange hurt classified sources in American national security. Utterly false. This is always the lie that they tell. It's always the lie. But look at what they did. They actually ruined a potential high-ranking source and anybody affiliated or associated or vetted or vouched for him. They're the ones getting informants outed, not anybody else. And this is who and what they're all about.
Oh, and Robert. Yeah, sorry. Go ahead.
I was going to say it goes to the whole to what's going on more systematically, which is if you can't sue the feds, can you sue the state or local government? Hopefully you can under 1983 laws. At least they recognize that if you go down the power chain, then they do allow suits to occur. The higher up the power chain goes, the more they don't allow suits to occur. That's the only real consistency in these cases. But the big Electronic Frontier Foundation report this week unmasked that all that geolocation information is actually being used by local police forces all across the entire country to map out your entire life. And that's because people didn't appreciate or understand how apps really work and why they're free.